Good afternoon and good morning, everyone. This is Dismas Locaria from Venable. Apologize for the delay. We had a little bit of a technical issue on our side here, but everything seems to be a go now. Welcome to our monthly Venable webinar. This month we are talking about the proliferation of suspension and debarment, how to avoid it. I'm joined today by Rod Grandin, the Managing Director of Government Services at Affiliated Monitors. So I welcome Rod today.
Thank you.
Unfortunately, Melanie Totman is dealing with a client emergency and was unable to join us, so it'll just be Rod and I talking today. So hopefully we'll keep you all entertained for the next hour and a half or so. But thank you for joining and thank you for bearing with us on the technical issues. So here's our speakers today. Myself, Melanie is unfortunately not able to join, and Rod. But let's kind of frame things up a little bit. By and large, when I put this webinar together, I was thinking it would be more of a kind of a graduate level course. I do want to touch on suspension and debarment generally, but we're not really going to dive into what is suspension and debarment in a great amount of detail, because I do want to spend more time talking about kind of the trends that we've seen across the years, and talk about more of the nuanced approaches to dealing with it and avoiding suspension debarment. But just, if there are any listeners who are new to this, just to frame it up a little bit, suspension and debarment, in my view as a government contract attorney, is what I think is the government's most powerful tool for protecting taxpayers and the public fisc from doing business with contractors or organizations that the government deems to be lacking in integrity or business ethics. And the word that's commonly used and candidly the standard is responsibility, and whether the contractor or the organization is presently responsible is the term of art that we'll be using in today's discussion, and that is widely used in the suspension debarment field. There's a little bit of a difference between suspensions and debarments. Both of them have pretty serious consequences to the contractor or organization because it will exclude them from receiving new awards from the federal government. And by awards, that can also include things like grants and certain other benefits, subsidies, and tax benefits and things that the government might be able to provide to organizations. So awards is a very broad term. We'll narrow it to contracts in this discussion because that's the primary focus, but keep in mind that it can be much broader than just a contract. But a suspension is a temporary exclusion, the idea being that there is enough evidence, or adequate evidence is the standard, and that there's an immediate need. And so, but the government still has an ongoing review or investigation into a particular contractor and their conduct. For instance, if there's a large procurement that is pending, but this contractor is being investigated for some type of fraud, would the government, and there's enough evidence to say that, there's likely an issue here, would the government want to take action to prevent them from receiving this very large contract? A suspension is a tool that they can use to do that. Debarment is slightly different because it's not meant to be a temporary thing. A debarment, while it is set for a period of time, the suspension typically doesn't run more than 18 months. It can be extended, but it's supposed to be for an immediate need. Debarment is supposed to be for a period of time. Typically, it's 3 years. We've definitely seen them longer. We've seen them shorter, and you always have an opportunity to go back and try to have reconsideration for time served. But a debarment is when the government has already conducted that investigation or already has that information available, and they're going to go ahead and disqualify that contractor from future procurements based upon that information. And like I said, that's typically for a 3-year period. The idea of this is not meant to punish contractors. It certainly can come across like that, and it can have some very dire effects on companies. But the idea is really to protect the public fisc, that the government is not giving money to tax evaders, fraudulent companies with, or organizations just with bad business ethics and integrity. The government, it's really considered to be a business decision by the government. It has certain legal requirements but it's a business decision that they don't want to do business with a company that exhibits the type of conduct that the company might have. Keep in mind, because it's a business decision, while there are some basic legal requirements and constructs, there is a lot of discretion. There's a lot of discretion in terms of what they can consider, and a lot of discretion in terms of how they can interpret and use that information. Okay, so that's kind of the basic 101 on what suspension debarment is. And like I said, I really just wanted to give that basic information just to set up the rest of our discussion today. So let's talk about some of the trends toward the increase in suspension and debarment. So about 7 or 8 years ago, we started to see a decent amount of activity in this space. We saw the Clean Contracting Act. We saw a GAO report. And these things were starting to say, hey, look, we, the government, aren't doing a good enough job of really marshaling our efforts to ensure consistency across the government, and that we are really holding contractors, those that receive federal funds, to a standard of, integrity and business ethics. And so these various things occurred. And what stemmed from that, let me talk about the GAO report real quick. The GAO report found that a number of agencies had little or no activity, and so there was a real gap in consistency, right? You had some agencies very active. DoD and by and large across all the services were very active. The EPA has always had a strong program. But there were a lot of agencies out there that had no program or were very little activity. And so the GAO looked at it and said, hey, look, there's a few agencies out here that have dedicated staff. They're trained to do trained to look at these issues and to carry out this program. They have detailed guidance that both for them to operate under, but also for contractors to take notice of and to be aware of. And then they had an active process for reviewing matters, an active referral process. How does a suspension debarment officer or official know that a company is exhibiting unethical conduct? They had a process to build that, to learn that information and for that information to bubble up to them. So they identified these characteristics, and they said, we really need to do this more at a government-wide level. And so the statute, let me go back here. So Section 8739A7 of the Duncan Hunter National Defense Authorization Act, I think, is really key in this, because there had been this agency that existed called the Interagency Suspension and Debarment Committee, and that had existed for years. But it was really informal. It was never formally recognized. Well, the Duncan Hunter Authorization Act recognized it for the first time and actually mandated that they issue a report to Congress, an annual report on the suspension and debarment activity of every agency. Well, now that every agency is ending up with a report going to Congress about their efforts, what do we think happened? Well, we see a sharp increase in activity over since 2009, 2010, and then you see in 2011 and 12 things really start to jump up. So you see some very big numbers there across the government in terms of suspensions going from just 410 or 417 in 2009 to a high of over 1,000 in fiscal year 2014. Similarly, on proposed debarments, you see going from less than 1,000 to 2,200 in fiscal year 2013. And on the debarment side, you see going from 1,500 to a high of 2,300 in fiscal year 2011. So what you saw was just a tremendous increase in activity, and that was across the government. But it's worth noting with respect to even an agency like DoD, which I mentioned before, all the services had been already pretty active in this area, but they got even more active. So look at the 2011 numbers, and you compare that with the 2014 and 2015 numbers, and you see some market increases there. Now, one of the things to keep in mind, and Rod, I'll ask for your thoughts on this in a moment, is in fiscal year 16, we are seeing a little bit of a drop. And so what we're seeing maybe is a leveling off, that things maybe really peaked from 2012 to 2014, 2015, but now in 2016, all the agencies are up and running. and they're starting to be maybe a little bit more discriminatory in terms of the cases they take and the cases that move forward, which is great. The bottom line is, even if they are leveling off a little bit, however, it doesn't appear that suspension and debarment is something that's not going to be with us. It certainly may be leveling off, but it's certainly an action that is not going away. And here's some stats on USAID in that same time frame, and you see in 2012, the referrals just jumped off the chart. 2009, there were 10 referrals. In 2012, there was over 130 referrals, and debarments went from 0 to 37, obviously, in that time frame, and still they're at a pretty high level in 2016 with 22 and 25 proposed for debarment. So, on an agency level, we've seen a little bit of tailing off, but agency by agency, some of them are still getting more up to speed and creating even greater activity. So I wanted to kind of go through those numbers a little bit first, so then we can now kind of bring Rod into the discussion and talk a little bit more about this. But before we get into kind of the avoidance part of it, I wanted Rod to get your thoughts on these numbers and what your takeaway is.
Okay. Well, first of all, I would just point out that the preliminary look at fiscal year 2017 also shows a further reduction in the overall number of actions. Again, still up significantly from 2009. There's still thousands of these actions going on in any given year. A couple of thoughts come to mind. One, you go back to the GAO report 11739, which spurred activity on the part of industry, or of government, to take their oversight responsibilities seriously. What we saw across the board were so many agencies that simply had no suspension debarment activity whatsoever, no designated officials, no resources, no staff. Now you come forward 5, 6, 7 years, and what you see is now almost every agency does have an established suspension and debarment presence, designated officials to run the programs, in most cases staff to support those programs, and some resources to manage the programs. But you're also seeing other trends that practitioners must be sensitive to and industry must be sensitive to, and that is some agencies are choosing to have their fellow agencies step in and take on particular matters due to complexity, perhaps conflicts within the organization. This type of activity it just did not happen in the past. And as you move forward, certainly my impression over the last couple of years, there was quite a bit of this sharing of responsibility going on. Joint reviews are also becoming more common, particularly within the agencies that have a lot of commonality. The DoD agencies, Army, Navy, Air Force, DLA, to a certain extent NASA, there's a lot of overlap. And we saw in the last couple of years a lot of activity by these agencies to get together when there was a contractor that crossed essentially all of their horizons to assess these matters. And from my perspective, very positive development. The last thing a company needs is to try to figure out when they have contracts with various agencies where they should go.
Yeah, I've had some struggles in the past with this concept of lead agency, and it's certainly, I think, more advantageous to the contractor to work with multiple agencies at once. I've heard of issues of forum shopping, people going to certain agencies as opposed to other agencies, even though under the FAR, the rule is you're supposed to go to the agency with the highest dollar value. However, as you and I both know, sometimes the subject matter doesn't really lend itself to that agency, or while one agency may have a high dollar value, another agency may also have a very high dollar value, maybe not as high, but has certainly a vested interest.
Yeah, lead agency continues to be what I think is a problem in need of a solution. It's still not, in my view, transparent enough within if you're an outsider, if you're a company that has a potential problem, and you're trying to figure out where you should go as your entry point, and you have contracts with various agencies, it becomes very difficult to figure out what is the correct entry point. And sometimes dollars just don't drive it. And
right.
There should be some effort on the part of the government to assist industry. I think these joint efforts are certainly.
Yeah, no, that's great. I recall 7 or 8 years ago I worked on a matter, and we went to the agency we believed to be the lead based upon the type of issue, conduct. They didn't want it. The agency with the dollar value didn't want it, and so we got pushed to a third agency that no one then wanted to even pay attention to their decision. So it certainly created some problems for us, because we wanted it to be reviewed by an agency with authority, because some of these agencies back then didn't have a program, so they weren't really respected by the agencies with a program either.
Right.
So I think it's helpful to kind of this joint agency review is not necessarily a bad thing. I think that's helpful.
And there's another, I think, major factor in addition to the GAO report that spurred a lot of agencies into action. The mandatory disclosure rule became effective back in December of 2008. Mm-hmm. Around 2010, the infrastructure was in place, information was flowing, industry started making disclosures. And for those of you that don't know, the disclosures come into the contracting officer and the agency IG. In the case of the Department of Defense, it goes to the Department of Defense IG. The IG, at least within the Department of Defense, then distributes those disclosures to each of the military agencies and to DLA. So suddenly there was this new input of information that basically touched on misconduct or matters that.
Right.
Dealt with integrity. Mm-hmm. The suspending and debarring offices sort of struggled with what to do with that information in the 2010-2011 timeframe, and ultimately, I think the collective approach was, hey, this is information, even though these are reports from industry, in many cases, the quality of the information was such that it was actionable. And the decision was made that when this information was sufficient to form an action, and there seemed to be a reason to take steps to protect the government's interests, the agencies did so. And that, I believe, also had a significant impact on the increase in actions in that 12, 13, 14 time frame.
Yeah, no, I agree 100%. I also think the government, because of some of the statutory changes and the GAO report, I heard that the Department of Justice was becoming more formal in terms of, cases it was prosecuting, were kind of referring those matters more consistently than they had in the past. I think there was just an overall more coordinated effort by the government, which, isn't necessarily, conceptually it makes sense, right? That the government's acting in a more coordinated fashion.
Well, certainly you see that within the agency. Again, my example is the Department of Defense. There's a formal regulation or a policy in place that requires this coordination effort. So when the IGs receive information, they are supposed to share it with, if there's a contract matter, the contracting officers, if there's something touching on integrity, to the suspending and debarring officials. Fraud matters are supposed to go to the agency fraud coordinator. So there's this great effort within the agencies. I think DOJ continues to be a bit of an outlier. My impression was always that, they're trial attorneys, and trial attorneys are control freaks, and they like to control their information. And by gosh, if an agency SDO stepped in, well, that's a potential loss of control.
Yeah.
So they keep their information pretty tight.
Right. No, absolutely.
So there could be some improvement there.
Sure. Absolutely. So I think, it looks like while we're seeing maybe the leveling off, we had a peak, like I said, but a leveling off now, there's no question now that all the agencies have, debarment programs set up, that it's here to stay. And so, I think the crux of today's conversation is really to talk about avoidance, and not avoidance in terms of being proactive, right, and not being reactive. And we can talk a little bit about reactive later, but I'd like to dive into and get your thoughts on, some of the things about preparing for avoidance.
All right. Obviously, there's much that can be done, and frankly, there's now a regulatory construct. If you look to FAR Part 31000 and 52-203-13, you now see a requirement that that industry is supposed to have in place of certain dollar thresholds, contractor codes of business ethics and conduct. This sort of sets that expectation for integrity with the government customer. So that's a very good starting point for any activity that wants to do business with the United States government, is to look at what you are doing as a business and to build a code and a set of expectations for ethical conduct and business conduct that are appropriate for your business operations in terms of the regulatory risks. Are you exporting? Then you better have a fairly sophisticated export control system in place. Accounting, it goes without saying, you need to do a good job of capturing your costs and so forth. So, but it's critical that businesses tailor this to their own operations. So you now have a new baseline. There are a lot of other emphasis that can be found in the policy. You have the U.S. sentencing guidelines, which is, I think, along with the FAR factors and those factors set out in the non-procurement rule that are used by suspending and debarring officials to assess responsibility. The sentencing guidelines are also out there. They exist primarily to help judges figure out how they should assess penalties. But they also lay out a roadmap for industry to embrace before there's a problem. Starting with that code of business conduct and moving into, okay, so we have a code. This is how we conduct our business. How do we then incorporate or integrate these behavioral expectations into our business operations? Do we have an effective training program? Does the company leadership truly buy into this proposition of doing things the right way? Is their messaging appropriate to incentivizing the workforce to do things the right way? Again, a lot of these are captured very carefully in both the FAR, the Sentencing Guidelines, the Foreign Corrupt Practices Act guidelines that are put out by the Department of Justice. These things all really boil down to a company's need to have in place reasonable and effective programs to prevent misconduct from occurring in the first place, to be able to identify or detect misconduct when it occurs, and then to have also an infrastructure and willingness to take appropriate remedial steps when there are problems. Right. So those are the main three anchors for this, for, I think, avoiding it. But certainly there's an opportunity for a deeper dive.
Yeah, let me parse some of that out, because one thing you mentioned, there's those anchors, but then, and you said, appropriate for their industry. And so what we see is a lot of contractors. Okay, we've got to have this, compliance program. We have to have a code of conduct. What needs to be in that? Tell us what needs to be in it. Well, the FAR doesn't really get into the nitty gritty, right? Because they want no one size fits all. And most people say, well, what do I need to do to check the box? And that really shouldn't be the approach, right? What should I do to check the box? Right. It should be, what do I need to do to have an effective compliance program in place? And so really, it takes some critical thinking on the part of the company to say, here's what we do, here's our industry, here's our exposure, and here are the types of programs, the policies that we need to ferret out misconduct, to bubble that up, and to maybe even proactively address it, right?
Right.
And I think that's always the rub for contractors, right? Because there's a cost. There's a cost to everything. Whether large or small, it's, how do I check the box? But then it's also trying to get them to think, not a check the box exercise.
Right. and that's the problem. The bedrock for all this is to have, again, this code, these policies in place that sort of outline what is the expected desired conduct or behavior on the part of the workforce. If it stays as just a set of written documents, it goes nowhere. Truly, there's no opportunity for improvement, and it isn't going to help you in the long run should an SDO come knocking. The crux of this, though, is even before you get to your code of conduct, businesses, small, medium, large, doesn't matter. Every business activity must be tuned into its risk profile. And there should be a flexible, ongoing risk. I call it a risk loop. What are my risks? What are my operational risks? What are my regulatory risks? Am I doing business in emerging markets that, where the rule of law may or may not have much teeth? what is the risk situation? Once a company identifies its risks, in many instances, I mean, there's risk practically anywhere you look in anything you do. Prioritizing those risks, and then figuring out what are the appropriate compliance structure to deal with this risk profile. Again, do you export? Well, how do you capture your costs? What is your purchasing system like? Are you working in emerging markets? Are you handling classified, sensitive information? It all really depends on what that business operation is about and what that ongoing risk assessment is about. And I emphasize the need for this to be a flexible, ongoing process. I don't know if there's any, quarterly, annually, whatever makes sense for the business, but it cannot be static. And I cannot tell you how many times very sophisticated businesses came before me that had essentially a static assessment of their risks. In many cases, we were looking at conduct that occurred in the 2012, 2013, 2014 time frame, in which companies had policies that had been developed in 2009, 2010, that had been based on the risk profile back in 2009, 2010, that hadn't been changed even to the present day.
Right.
And again, that is just a recipe for disaster. As those companies had continued over the years to move into different markets, different product lines, certainly the regulatory schemes changed constantly.
Right.
And to not keep track of that was just a huge problem. So small businesses, right now my comments have been targeted mostly at larger businesses.
Right.
But smaller businesses, smaller businesses think that they don't need to play this game. And I think that's a huge mistake. Their game is far simpler to play. In many cases, if you're a company with 50 employees, that leader, that CEO, that president, that owner knows all 50 employees and has the opportunity to impress upon each of those 50 employees what the expected behavior is. Does there need to be extensive policy? Probably not, because they can talk to each other and communicate to each other. But it has to be in place, and it all has to start with an appropriate, flexible, ongoing risk assessment.
Yeah, you bring up a good point with small versus large, because the large defense contractors are sometimes better positioned to absorb the cost of a robust compliance program. But the small ones, they're trying to make ends meet. And the scalability, we get a lot of questions about the scalability. And I think you make a good point, which is, look, your exposure is less because you do less, right? You're not spread out globally, perhaps, or maybe you are. But you have less touch points. But you mentioned, the idea that maybe you don't have to have policies, and maybe you don't have to have the formal processes, I guess, that a large corporation might have. But then I would say, what are your thoughts? Should the misconduct of a small entity be raised? How would a small entity that has more informal practices be able to present that? Because I think a lot of times people do more than they think they do. They're just not thinking about it, and they're not documenting it, right? Because they're always talking about, the corporation, by and large, most companies want to do right. They don't want their employees to be harmed. They don't want to violate the law. It may not be top of mind that they're doing that, but they are in some ways doing it.
Right.
But it might be difficult to demonstrate. It might be difficult to prove to a suspension debarment official. Right. Any thoughts on that?
So one of the handicaps of the suspension debarment system is that it's a record-based system. So if it doesn't exist in writing, and you heard this before, it doesn't exist. So you touch on a good point, and frankly, I oversimplified. My point being, these efforts are entirely scalable for small businesses, but it should be captured in some type of a written process. What I was trying to suggest is you don't need reams of HR policies.
Right.
You don't need a manual, a procurement manual. What you need is in place, again, bedrock is to understand your risk. Secondly, have that code that is attuned to your risks and that sets out the desired business behavior. And frankly, there's no magic in those documents. The magic comes in integrating what is in that code into the business operations. And that's where I believe it would be useful to have some sort of a written expression as to this is the behavior that we have in place. and this is how I, as a leader of this company, or I as the owner, president, whatever, this is how this company is going to execute this. These are our expectations. If an individual or in the workforce violates these expectations, we will review it, and there will be appropriate consequences. Maybe build incentives into the bonus system or the performance evaluation system. These things should be captured. Again, they don't have to be in reams of paper,
right,
but they should be captured. I mean, every company above, say, one employee
right.
should probably have in place something that standardizes or it captures the expectations and at least from a rudimentary standpoint, what the company is going to do to achieve its desired outcome. I mean, clearly, a company that manufactures, a small company that manufactures, isn't going to venture into this space without having production plans in place, a safety approach.
Right.
Those same things need to be captured, probably in the same level of detail, to address these. What is the expectation of the workforce, or about the workforce, in terms of doing things the right way?
Yeah, and I do find that sometimes it's very simple. I mean, we've talked about tone at the top, right? It needs to be a message that's impressed from the top management, and people got to believe it, and so, I find that there are sometimes some simple things that smaller organizations can do. A large company that has thousands and thousands of employees, it often will send out newsletters and things like that via email or some other method to communicate with, because there's just too many people. But you use a reference of being able to actually talk to all the workers. And that's great for small companies to be able to do that, and I think that's more impressionable than sending out a mass email. But I think it always makes sense, follow it with an email, right? As we discussed at our staff meeting today, or X, Y, and Z, and then lay it out in the email. Then you've got, and if you do that quarterly, should misconduct ever come to light, look, this is always top of mind.
Right.
We have bad apples. Everyone's got bad apples. We certainly don't endorse it, and we've tried to impress upon people the importance of doing things the right way. We have quarterly meetings where we talk about different issues. And if you summarize it in an email and blast it back out and say, as we discussed in our meeting today, I just think that's a simple way for small organizations to maybe capture some of these things that are done more informally.
Yeah, and I think for a professional services type of an organization, spot on, because most of your workforce will have access to email.
Right.
But what if you're a manufacturer?
Right.
All right. Your folks on the shop floor don't have that.
Right.
So then your challenge is a little different, and that's where that face-to-face, if you have all hands meetings on occasion, to just start those meetings with 30 seconds. Hey, this is what their expectation is. This is what the way we're going to approach it. And oh, by the way, employee A did this last week, identified this problem, brought it to management's attention, problem solved, potential things averted. I mean, just highlight the goodness that goes on. Costs nothing. That
last point's a great point, because I tell clients this often, which is it's great that you take reports and you look at them and you analyze and you determine whether or not it's an issue, right? The person who gives that report is saying it because they're concerned, right? A lot of companies, I find, fall down by getting back to that person. So if the person's even if they are anonymous, was anything, like I saw an issue, I thought someone violated a timekeeping rule. I raised it. Now, there may be a million reasons why it's not an issue, but that person was concerned enough to raise their hand. And I find that lots of organizations don't get back to that person to say, hey, we looked at it. Here's why it was an issue. Here's why it wasn't an issue. And sometimes it's difficult because it's anonymous. But there's, I talk to clients who say, in your newsletter, you should have a little section in there on compliance reports.
Right.
We've got, X reports, detailing X, Y, and Z. And you can be very general about it. But at least it gives those people who were brave enough to raise their hand the satisfaction of knowing that the organization took it seriously and looked into it. And it helps the organization, I think, because then you have an individual who has some pride in their organization. They work in a place that they can feel proud about. And they don't have to run off thinking that they have knowledge of some nefarious conduct and that they need to go tell an IG, and then it gets outside the organization, whereas the organization's better off handling it internally. But it's that follow-up with the person.
Right.
And you touched on that, and I think that's a critical piece for companies to think about is how do you, when you get reports, how do you disseminate the information back that you've looked into it and you're addressing it in a thoughtful and responsible manner?
Right. And what you're really touching on here is the communications, intra-company communications. And what, in my experience, what I have seen are in most cases, fairly effective communications from the leadership down. That is, they will tell the workforce, these are our expectations. Where they fall down, in many cases, the communications back up. Mm-hmm. In many cases, it stops with an anonymous helpline or hotline or whatever you want to call it. And it doesn't go beyond that. And that's a huge miss. I think the most effective steps are when you have good flow of communications going down in terms of those expectations and avenues for those communications to come up. And not just saying, I think misconduct occurred, but to empower the workforce to simply ask questions. You know, we're doing it this way. Does that make sense? And are we giving the best value? Right. And I think, and I'd really like to see more study in this area, but I do think that these programs to promote ethics, compliance, values-based approaches to how things are conducted in the business space, I would love to see more studies on how that relates to revenues. Mm-hmm. And returns, because I just think as the human response is, if I'm respected, if my voice is heard, as you point out, I'm going to be committed to this organization. I'm going to work harder, and I'm going to try to, when I think I have some way of doing it better, I'm going to raise this. Right. Anyway, just... No,
I agree. But
we get off topic.
No, but it's a good point. I mean, I think there's some areas that these types of things, they will, I think, overall improve the workforce. Let's pivot to individuals a little bit and talk about, well, I know, first of all, you have some numbers on individual debarments. And so one of the numbers we didn't really present is that we didn't break it out by companies versus individuals. Your thoughts on the numbers first, I guess.
Yeah, I think if you look back over the last couple of years, 2015, 2016, fiscal year 2015, 16, and now into 17, what you're seeing are almost 70% of the total number of actions are against individuals. This is a stunning change from, say, 10 years ago, where the focus was almost entirely on corporate or organizational conduct. Again, I attribute a lot of this to the mandatory disclosure rule. Suddenly you have companies coming in and saying, this occurred, and oh, by the way, these five...
Now we sue over here.
Yeah, these 5 employees did it. Right. We fired them. So, again...
So we did right, go get them.
Go get them, exactly right. And so you see this spike in individual actions, which... Just as a side note, I mean, the Department of Justice in the Yates memo was also sort of saying, hey, this isn't necessarily a wrong thing to do. In fact, this is probably a good thing to do because organizations only work through the individuals that are manning the switches and turning the dials.
I was going to bring up the Yates memo and whether we think that's probably the impetus to this focus on individuals. Or is it more of a focus, as some may have said in industry, that agencies are looking to get their numbers up.
Well,
and individuals are maybe easier prey.
Ow! I'm not on the receiving end of that numbers up anymore. But here, so the bottom line, no. I would attribute this focus to individuals on one, the impact of the mandatory disclosure rule, and then 2, separately, if you look at what's going on across major contractors, particularly in the DoD space, but I'd say more generally across the federal marketplace. Our major contractors, the major contractors out there, have embraced this notion of ethics, compliance. They've embraced these authorities and guidelines, and they've built large organizations have built tremendous infrastructure to support carrying out exactly what these guidelines and these authorities say they should do. In doing so, they have put themselves, again, going back to my 3 anchors, the ability to prevent and then to detect, they have put themselves into a position where their controls now provide them fairly quick feedback on behavior that is not within the norm. Right. And they're very quick to say, look, disciplinary consequences flow from that type of behavior, and prophylactically, we're not going to go to the government with this disclosure. So So you've got the mandatory disclosure rule that probably spurred certain behavior, combined with the fact that industry raised the bar on itself. If you think back in 2010 and before, it was very, very rudimentary. Companies were just awakening to the notion of, what does this all mean? And, you had some of the scandals of the late 2000s, and,
right.
Companies did not want that kind of problem. So they raised the bar on themselves. They raised the bar in their workforce in terms of what is permissible behavior. And so you see these individuals flowing out of it. Now, the sad part of this is right now the authorities in place, both in the procurement rule and the non-procurement rule, are not really geared
right.
towards assessing the responsibility, going back to your introductory comments, the present responsibility of individuals. And that's another area where I think there needs to be, folks need to roll up their sleeves and figure out how do you build in some objective criteria for assessing individual responsibility.
Now, one thing that practicing in this field, we see, there certainly are people that are bad apples. And I understand, those bad apples, it probably makes sense for the government to go after and assess their present responsibility. But sometimes, you'll see the disclosure, the company points the finger at the individual, but then you peel back the onion on the individual, and they really weren't equipped to do the job the way they were supposed to do the job. They didn't have the right training. They didn't have the right understanding of the rules. And I assume you had seen that in your previous role. And so then it kind of flips it back to the company to say, well, hey, look, you're pointing the finger at these guys, but you didn't really empower them to do the right thing, to be able to know what they were doing. Any thoughts on that? And
well, so it's interesting. I'm going to segue just a wee bit into the American Bar Association Suspension Debarment Committee, which you and I are both involved with. Tomorrow's meeting will focus on exactly these type of considerations. And one of the topics that there seems to be complete consensus over is if an individual has been identified as engaging in misconduct, has come from one of the factors should be, were they made aware of what is expected of them from a behavioral standpoint? Did the company have in place these policies and an effective training program? If it didn't, then I'm not saying credit to the individual, but it's
takes away the culpability, right? I mean, if they don't know any better, then how can they be responsible?
It becomes an extenuating consideration. On the other hand, if they came out of a Boeing or a Lockheed or pick your major defense contractor where there are Northrop Grumman, where there are very, clear guidance and very effective programs, and they still engage in it, that is going to be a consideration and aggravation. Mm-hmm. So, absolutely. And but again, companies have raised this bar, and the individuals, I think they're starting to tune into this. Certainly at the major prime level and the major contractor level, where I believe industry collectively still has a problem, both organizationally and from an individual standpoint, is that mid-tier and below, where behaviors are not being expressly called out, the desired behaviors are not being expressly called out, they're not being effectively trained into what is expected, and frankly, the individual employees left to figure it out in those cases.
What about thinking of kind of the mid or small companies where the company is almost synonymous, with the founder, or with the executive, the owner of the company. And the company has a position, but then that individual obviously benefited, maybe monetarily because they cut corners and they were able to maximize revenue on contracts. So I think that also presents different problems. You have the line worker individual, but now we're talking about the executive individual, and especially when they're the owner, and trying to segregate the two so the company doesn't have to be debarred because the principal is the bad actor. That's always a dicey proposition.
It is interesting that when you have a company that is its owner and or at least an extension of its owner, and the owner engages in bad behavior, it is very, very difficult.
Or doesn't even want to
parse that.
Or doesn't want to institute a tone at the top, They're kind of, we'll worry about compliance later. Let's get captured. Let's get contracts.
Exactly right.
And they're just not, it's not as though they're acting overtly nefarious. They're just not prioritizing it to a degree that the government says, hey, these are the types of companies we want to do business with.
Right.
And sometimes that's, you just need to give them the Riot Act and then they shape up. But in other cases, they almost laud their kind of cowboy mentality.
Right.
And those are the ones you got to be concerned about, right? But then you've got 500 people that work for this person, and they're going to lose their job because he or she wants to be a maverick.
Right.
So it's definitely a challenging situation.
It is a challenging situation, and frankly, not an uncommon situation from a suspending, at least from my practice.
Right.
There were almost cookie cutter incidents that I saw over and over and over again that involved a company that started, say, 5 years previously with an idea, maybe a patent, something going for it, and then grew magnificently to a company of, say, 50 or 100 employees and revenues now in the millions in a very short period of time. And the whole focus of the company is on revenue generation.
Mm-hmm.
Lacking is any infrastructure to support that organization. And when I say infrastructure, no HR policies, no accounting, no thought whatsoever given to accounting other than maybe some QuickBooks stuff going on.
Right.
And God forbid they're in the export environment. You would see this happening over and over again, and you just go, oh my goodness. But this focus only on revenue is a stumbling block for a lot of successful businesses, or at least successful in terms of the ability to capture business and grow revenues. But there has to be smart growth, and that, as you in your role, having the opportunity to talk to clients and to get in there, I just think that's a value added. And any time you're working with a client and you see that maybe the controls are not as robust as they could be or should be, it doesn't necessarily cost them anything to have your thought. And, you might generate some business there too. But, the point is, sometimes businesses can't see it. And you're right, it's not that they're acting out of mischief. They're not trying to cut corners. They're focused on,
they have a sole focus.
Singular, that's right, singular focus.
And especially as you grow, obviously your exposures grow.
Yes.
And so, when you have one contract, compliance isn't that difficult. When you have 15 and now 30 and 50 and 100 plus, and you're now several millions in revenue, and you've got new staff, it starts to get unwieldy, and sometimes quick growth can be problematic. Let's talk a little bit about some of the things. I think the Civil False Claims Act is probably, the one area that everyone, yes, you need to be worried about suspension, debarment if you're accused of violating the Civil False Claims Act. But let's talk about some other areas that people should be mindful of. I mean, there's certainly specific, Clean Water, Clean Air Act, statutory debarments, but some thoughts on some of the typical and then maybe even some of the more unusual areas where the government would assess responsibility and say that is something that we think is unethical and it should therefore warrant administrative review. Right.
So let's just start with a practical look at a more robust suspension debarment system, and there are several of those across the federal government. The staffs in those offices, the leadership in those offices, review the papers. They watch the television. They see stuff on the news, and when something comes across the print or comes across the screen that is one of your contractors, and it's one of your contractors, you may not have that file in front of you from the investigator.
I hope it's not tweeted. Yeah. Be careful if it's tweeted.
That's right. But you can bet that is going to, the first thing that's going to happen is, oh my goodness, really? Because frankly, and at least in my case, when these things happen, come across the print or come across the screen, very likely within a very short period of time, I'm going to get an email or a phone call from, somebody at the senior level of the agency going,
I was watching.
Yeah, I was watching. If I saw this, what's going on? Right. What can you tell me, and what are we doing about it? I want to know. And by the way, give me 3 quick bullets for responding to any press inquiries.
Right.
So, number one, don't think just in terms of enforcement actions. Think about, if you're a company, think about what is in the public space. Mm-hmm. Particularly negative information in the public space. An investigation, it just launches, may not go anywhere, but now it's in the public space. it's likely to draw attention to you. So just that's number one. Number two, the False Claims Act, those are usually tied into agency actions. Agencies are involved in working with the Department of Justice on whatever the remedy is or the settlement is, or building the case if it goes to trial. So the agencies are very tuned to that. Suspending, debarring offices in many cases also wear the hat of the agency fraud coordination coordinator, and so they're plugged into this flow of information. So not only though on the False Claims Act, but contractual disputes, contractual matters. Frequently, I have seen matters kicked over to our area on the suspension debarment side that I thought were purely agency disputes, agency contractor disputes, should be handled as a contract dispute.
Right.
But the point being, if a contractor is engaged in a dispute activity, and there are allegations or there's rumors that perhaps there's also misconduct, numbers fudged, performance was fudged.
Right. It depends on the dispute, right?
Right.
If it's a change order dispute, it might not be that big a deal, but if there's concern over mischarging, defective products, things like that.
Yes, that can very easily become a matter that's kicked over for suspension debarment. Foreign Corrupt Practices Act, that's another area that certainly my office used to follow fairly closely. In some cases, they may not have had these companies would not have had any relationship to the Department of Defense. So be it, and that was not our area. But in many cases, you would find companies that were engaged in these investigations, or there's a settlement or something going on in that area. And that typically also is going to result in a review. So I go back to the basic notion. Companies should broadly think about what information is in the public space.
Yeah, one that I've seen some activity in is default, termination for default, where the agency felt that the contractor kind of was just cavalier in meeting its contractual obligation to perform. So that's one area I think that people don't necessarily think that that's a potential repercussion of a default. It's one thing, it goes on your record, and it's very difficult to deal with if you have a termination for default on your performance record. So first of all, that's problematic.
Right. Well, understand, a lot of agencies actually do scan FAPIS, that type of information.
Right. And so then to be hit with a debarment action on top of it, it's almost compounding the problem for contractors. So they really need to, don't default on your contract, but if it's going to happen, you better have a good explanation as to why you're not able to perform.
Right.
So you aren't excluded. I mean, you're going to have a hard time, I think, getting a prime contract after that anyhow, but at least you won't be excluded from subcontracts and things like that. The other one, I'd like your take on it, I heard recently through the grapevine, was a discovery dispute, that in a commercial setting, there was someone was sanctioned because they didn't follow the discovery obligations. And they were proposed, or they got a show cause notice out of it.
Right.
And I guess in some context that might show a lack of integrity. If there's, willful destruction of documents, things like that. But it did seem to kind of jump out to me as, wow, that's kind of a new use that I hadn't heard of.
That strikes me as a bit extreme and probably more in the province of their outside counsel.
Right. Yeah, I've seen that happen.
But I would tell you that I do recall one matter, and it was brought to my attention. I don't recall exactly how this information came into to our office, but there was a state a contract dispute filed at the state court level involving an Air Force contractor. And the allegations were that this contractor had completely defrauded its subcontractors, hadn't paid, had abused them, and this information was brought to our attention. And frankly, if you're a prime and you're not paying your subs, that is a matter of responsibility, and that's going to get a letter, at least.
Well, especially small business too. I mean, there's some specific protections for small business subcontractors and that they get paid and on time and things like that.
Yeah, the point that was unusual there is that it wasn't brought through contract channels, which I would have expected.
Right.
And I had to scratch my head a little bit and say, why not? But that's a different story.
I've definitely heard of folks, using suspension debarment not only as a shield but also a sword.
I do actually. Now that you mention it, I do think it came in from a letter from counsel saying, "You wouldn't believe what this contractor is doing."
I have heard of that happening before. I will disavow any of my involvement in it. But well, let me and this is actually putting on your monitoring hat at Affiliated Monitors. Let me ask you some questions here. So we talked kind of proactively to avoid debarment, but now, unfortunately your programs weren't, or there was an issue, and now you're being reactive. You're being dragged in to respond to a show cause. I've actually found it useful when it's difficult to prove, when it's difficult to demonstrate the breadth and vigor of a compliance program, to bring an organization in like yours to do, first of all, the fact that you have the background you have, and some of these other organizations are made up of people who are former SDOs, and so your word carries a lot of, and you're independent, so your word carries a lot of weight with the existing SDOs. But I found it useful to bring in organizations like yours to do an assessment and to give me a documented thing to hand to an SDO to say, hey, look, I know everything's not perfectly laid out, but this organization really, the tone at the top is there. The message is clear. There was this misconduct happened because X, Y, Z. Right.
So, and you identify what I think has become the practitioner's playbook for responding organizationally to show cause letters or notices of suspension or proposed debarment, and that is so when a company responds, there's essentially three areas that are of particular interest. And of course, one is the underlying facts relating to the cause.
Right.
What happened? In many cases, company investigation may still be underway. They're in settlement negotiations with the Department of Justice. Whatever the point is, there may be reasons why that is a contractor or a respondent is not going to go in depth on those things. That's a challenge for the contractor and counsel. But so the underlying facts relating to the cause of the effort or the review. Secondly is, what did the contractor have in place before the cause goes in terms of ethics compliance? These things that are captured in the FAR and his sentencing guidelines. Did they have an effective ethics and compliance program designed to prevent misconduct and criminal activity from occurring and to promote ethical conduct within the workplace? What was that program? Was it effective? What evidence that it was effective? Okay. The third piece is, okay, now we have this problem, and clearly what we had in place was not effective or failed in some way. So what is the company going to do about it now? To improve it. And in many cases, again, as I said, it seems to be part of the practitioner's playbook now to go out and the second prongs, that is, what was in place, what are the gaps or potential gaps that led to the underlying misconduct, and what is the plan going forward to cover those gaps, to make sure that it doesn't recur. And that often, in my view, could be helped greatly by an independent, objective assessment. Challenge for counsel. Many law firms actually take that on themselves, the counsel, the law firm representing the client. And yes, the information is useful, but from my standpoint, you're an advocate. You're supposed to shape the information that way.
Right.
So getting that outside assessment more independently, more objectively was a very useful exercise. But
yeah, I worry a couple of things. One, the counsel does it. They're supposed to be an advocate. It's supposed to be, they're supposed to be putting it in the light best of their client. That's their duty. There's also, privilege issues. It's easier to cordon off if you bring an independent auditor in, an independent monitor in, go interview these people, go do that, and they'll assess it, and it's separate from my privilege.
Correct.
And I don't have to then breach my privilege. And I think to me, that's one of the real key. I think, first of all, the independence is I think, critical. I think it establishes better credibility with the agency. The second, I think the privilege issue is huge, and if you can kind of cordon that off, I think you're in a better spot. The problem is, again, large versus small, right? So sometimes it's about resources, and so some of the smaller companies, they don't have the ability to bring in another party to do something.
Right. But again, scalable.
Right.
Smaller organization. Again, these things don't have to be turn over every rock.
Right.
It's possible to go in and get a reasonable assessment of a baseline assessment based on samplings and so forth. So these things can be scoped in ways that limit the cost, limit the burden, but still provide useful information. And down the road, if it turns out it needs to go in a different direction, everybody has that flexibility. I think that's fairly straightforward and simple. I think that just if I could touch on it a little bit, when outside counsel does bring in an independent entity to do these type of reviews, there needs to be careful scoping and thought up front about how that privilege is going to attach.
Right.
Because you don't want to, you just need to make sure that you've got the right flow of information and that at the end of the day, that objectivity and independence is not undermined.
Absolutely. And the one thing you as counsel and the company itself need to be comfortable that what you find is going to be, and a lot of times, even to better position the SDO to assess the information, you have a direct line to them. In other words, your report's not going to come to me to sanitize it first. Your report's going to go directly to the SDO. It'll come to me too, but I have to have trust that my organization's going to come out. We're going to live with whatever you find.
Right.
And even if you find deficiencies, I find that approach with an SDO is helpful because the SDO is comfortable that the organization's trying to do the right thing. They're not trying to hide things. They're not trying to sanitize things for their eyes. I think you gain credibility with the SDO. At the end of the day, these are people making judgment decisions based upon a lot of different things that aren't in the regs. Because, like we talked about, it's a business decision. Well, they have to be comfortable.
A highly discretionary business decision. In many cases unbridled. It's just incredible how much discretion goes there. But if I could just go back to those 3 points again. So the cause, talking about the facts relating to the cause, what was in place, and what's the plan going forward. In my view, and when I was assessing these things, I was frankly less interested in the facts relating to the cause. I accept as a general proposition, and I know that this may have been a little unique, but if you think about it, in any organization, misconduct is going to occur.
Right.
All right, it's going to occur. So the fact that it did occur did not drive my decisions. I was more focused on what had the company done proactively to prevent and detect, and then how was the company responding? Did it go in and recognize that it had some gaps, that it needs to make improvements, that it wasn't dynamic enough? It's those second two areas that I think really carry the day when you're presenting information to an SDO.
Sure, the phrase fake news wouldn't work?
Yeah. Not with me, it wouldn't.
Well, we've got about 20 minutes or so to go. And if folks, I know there's a couple questions. If folks want to go ahead and send in any questions, we'll address those at the end. And just one parting question for you, and then we'll turn to the questions. Where do you think, what's the future of suspension debarment activity? Where do you think things are headed?
Okay. Well, first of all, you commented already that prior to the GA report and some congressional activity, the ISDC, the Interagency Suspension Debarment Committee, it existed, but it was it really wasn't driving anything. My hope is that entity will continue to provide leadership across the federal agencies. It's absolutely critical that the agencies through the ISDC continue to figure out how to make the process across the federal government more predictable. Right now there are still so many variations in how agencies conduct their operations. When they give notice, what is in the record.
Even the regulations that apply are different.
Right. The timing of the record. But the ISDC isn't necessarily, they don't have the power necessarily change those.
Right.
But what they do have the power and the ability to do is to transfer best practices. And I think that the ISDC is committed to that proposition, and I would expect that it'll be slow, but there's going to be a continued effort to try to bring best practices which would translate into more predictable outcomes, more transparency in the process, and frankly, a greater fairness in the process. So that's one. Two, I think it's going to continue. These actions are going to continue to decline a little bit, but I would expect there to get to a steady state. Right now, companies have invested. They're really pushing these themes of integrity down the supply chains. And I think ultimately that gets traction, and that will lead to more integrity, greater confidence within the marketplace. So, but at a certain point, it will plateau, and we're probably at or near the plateau at this point. But industry continues to have a role in this process, this overall notion of responsibility, and industry should pick this up because. When I would speak to industry audiences, I couldn't emphasize enough, it is your supply chain. You can't just pass the baton. It doesn't work that way.
Right.
And I think that theme is really caught on. And my sense is there's a lot of effort within industry, particularly at the major prime level, to push down throughout the supply chain desires, mandates, controls to promote integrity. And I think there's a lot of goodness there that will continue to play out. Another thing that's not really a trend, but right now there's some leadership gaps across the agencies.
Right.
DHS I think has an acting SDO. Air Force has an acting SDO. Navy has an acting SDO, as far as I know. But it's been a little frustrating that these things are not moving much faster. These are critical, highly discretionary roles. And for agencies to not move out quickly to fill these, I struggle with that.
Yeah, it really makes it difficult for the agency to set the tone of what the program is going to be. Looks like we have a question. It's a good question about host nations, and the U.S. and its contractors are embroiled in a lot of different hotspots around the globe, obviously. Some of them typically were not deployed to places like Denmark, where they're at the top of the list in terms of fraud, right? We're usually in places where there's a lot more kind of problems. And I think the question's going to, how can DoD contractors deal with kind of the word used in the question is predatory host nations. Any thoughts on that in terms of, and they're looking, are there legislative fixes or there, I guess, policy fixes to enable contractors to survive in what is sometimes very challenging political environment?
Right.
It's not even their own misconduct, it's they're trying to work within the system of the host nations.
Yes. And I sad but true that, no, I'd say contractors are pretty much on their own to deal with this. I don't see legislative fixes. I don't see regulatory fixes. And frankly, I don't know if they'd be appropriate. What we're talking, I think, largely about are facilitation payments, or going by a different name, corruption.
Right.
All right? Bribery and corruption.
Right.
Those are not going to be, that type of activity is not going to be sheltered, whether large or small. And you have, just look around the globe. The UK now has some fairly stringent anti-bribery, anti-corruption controls. EU, they could be a little more toothy in their application, but they're out there now. And I think that, if anything, the expectation of a contractor's conduct, even in these very troubled, dynamic, lawless areas, there's just not going to be any shelter there.
Let me ask you a question. If you don't want to feel comfortable answering it, that's fine. But so does an SDO weigh the practical implications of their decision? In other words, I represent a contractor. We're responsible for delivering food and water to the front line. In order for me to do that, I have to do some things that wouldn't be acceptable under U.S. law. In the culture and the environment with which I'm working, I got to get this food and water to the troops. Otherwise, the troops go without it. I'm going to do what it takes because I'm there to support the U.S. forces. How would an SDO, again, if you're comfortable answering it, but do you look at the practical realities?
Okay, so again, I caution that when I was in the role of the SDO, absolutely. I had perhaps a different approach than many, but perfection can never be the standard that you assess responsibility. Right. Or otherwise we're all going to fall short. Right. The assessment of responsibility has to be based on reasonableness. Mm-hmm. Was the conduct reasonable under the circumstances? And, when you're in a situation, I remember specifically a transport company trying to move its products into or out of Russia, I don't recall which, but, they had to pay dockside fees to get this stuff moving. Mm-hmm. And I found out about it through their disclosures, saying, look, our stuff is basically sitting on a dock, they won't give it to us, and we need to get it to the warfighter quickly. So we did pay this. All right, it was in de minimis, but of course there is no de minimis in these rules. Right. But from my standpoint, the fact that the company was able, again, to identify this conduct had occurred, and even though it was small dollars, they were able to identify, and this is a fairly sizable company. That is a sign of responsibility. Mm-hmm. Okay, the fact that they were willing to do what they could about it, they had in place the appropriate policies. Their drivers had called and said, I have no other options whatsoever. I don't have a choice. They had gone to the local police, and, of course, the response was a bit of a shrug.
Yeah, or they hand out their hand.
Yeah. Yeah, well, I didn't get there, but, the point is, so as I'm assessing this conduct, I said, well, that is the type of conduct I expect. We didn't have perfection in the outcome, mm-hmm. but to me, that showed that the controls were in place, the controls were working, and the company was doing what it reasonably could, to achieve responsible conduct as a supplier. So, that was like, oh, goodness, well, please keep me advised. And, now, next conversation I have with the Transparency International people, I say, you need to do more, because this is still happening all over the world. But I don't know if that's responsive. And frankly, I caution that was my response. Mm-hmm. This is a highly discretionary activity, and another SDO's response may be quite different. Right,
absolutely. And, I think that goes to some of the things you were just talking about in terms of consistency across the agencies, right? Because certainly, and the courts probably wouldn't look favorably upon such a disparate response from different agencies. Right. There needs to be some degree of consistency across these agencies. Otherwise, it does really drive us, counsel, to try to forum shop, right? We're going to try to look for a more reasonable SDO. I'm not saying we do it, but that's the incentive that it can create, is if you have an SDO that's completely unreasonable and one that is more reasonable, you're going to, your best move is to try to get in front of the more reasonable one.
Right.
So it does create some issues there. Another question. The question is, how do debarment rules apply to groups? Do they just look at the entity that's bidding, and could you therefore escape the rules by bidding with a sister company? So I guess we're looking at affiliation here.
Yeah. And so the answer is no.
Right.
But affiliation is, it's so easy for companies to morph into, something else.
Right. But if they do, I've seen the hammer comes down hard.
Oh, really hard, yes. Yeah, that usually will result in some criminal activity if you're successful as an agency. But I would say that no, that's not going to be a screen. That's not going to be appropriate. And frankly, I come back to my 3 pillars again. Right. What does a company have in place to prevent misconduct? When you get into those third-party relationships, a company must exercise appropriate diligence to determine what is this partner? What are they about? Right. Who owns it? Who controls it? Are they on the list of excluded parties?
Right.
Basic diligence must go into these relationships, these third-party relationships. That is going to be assessed as a matter of responsibility. That is one of those key, indicators of appropriate controls to prevent misconduct from occurring in the first instance.
Right. Let me go back to one of your questions about consistency again, because I've had the challenge.
Huh?
Well, I've had the challenge with clients to say, look, if I find myself in front of a less sophisticated agency, they often won't ask about affiliates. They won't ask that question. And the concern that I have is that if they find out about it 2 months into this process and something happens, they're then going to look foolish. They're going to have egg on their face, and they're going to come hard.
Oh, they're going to come very hard.
Right. And so I, like the Air Force and other agencies would say, in sometimes the initial responses, and give us the name of the affiliated companies. But if the agency doesn't ask for it, I've had to convince clients, hey, look, we need to tell them who your affiliates are and why this shouldn't apply to them is part of that, but be forthcoming about it.
Right.
And then say why they shouldn't be part of the action. They can be cordoned off. Obviously, you need to have a plausible reason for that. But the challenge that I have is I have to almost convince clients to do that rather than there being consistent practices. If it's in the notice, then I don't have to convince the client at all. Look, the agency's asking for it. But here I'm trying to convince the client and saying, look, it really is in your best interest to be forthcoming with your affiliate. Yes, there is some risk that they're not going to buy off on the cordoning off. But if they find out, if they find you've pivoted all your work to that entity, and that this whole action is a waste of they're going to come down really hard,
right.
and it's just not that's not how we want to conduct ourselves.
Yeah.
Being
disingenuous with the with your information,
and for me, I work with a lot of the SDOs, and part of it's my own reputation on the line to not. Otherwise, I'm going to go in there. I'm not going to be a very good advocate if they know that I'm trying to weasel out every legal nuance.
Right.
So it's definitely an issue to.
Yeah. Well, that response. So again, the three tiers. We go back to the response.
Mm-hmm.
The response. The obligation is to cooperate. What does that mean? Well, I believe that basic notions of honesty get incorporated into that.
Right.
And if a company is going out of its way to let's say they don't say anything dishonest, but they are not being forthright, well, that undermines that honesty peg. So it's as counsel, as a practitioner, and as a company, you've got to be forthcoming with the facts, the relevant facts and information. If it's bad, it's bad.
Right.
All right. But again, the focus should be more on what was in place to prevent. And what are you doing now to make sure it never happens again?
One of the, and this is for all the listeners out there, one of the challenges, and probably one of the reasons to bring an attorney in who has experience in suspension debarment, is that you're not looking to gain every legal foothold, right? When I work with my white-collar litigators on a matter, so they are defending they're looking for every legal nuance to gain an advantage. But here, because of the discretion, because it's really a business decision with some legal underpinnings, you can't glom onto, I have a legal argument for this. No, you need to be forthright. You need to be open and transparent. Otherwise, they have a lot of discretion and they'll bring the hammer down on you. And we always have a lot of back and forth with my white-collar colleagues because they want to, the law is X.
Right.
The law is X, but the discretion is vast.
Yeah.
And their judgment is vast. And so sometimes we're playing more, counselor than advocate attorney because it's not all about the legal nuances. It's, look, this is the way to move this forward. And so sometimes we have a challenge convincing clients, convincing colleagues, co-counsel, things like that.
Well, again, I tell you, your point about having experienced counsel is I think it's absolutely critical. Frankly, I would dread those matters where there was not an experienced counsel, and I had more than once. We'll put it this way: we had meetings scheduled, these meetings in opposition scheduled, and a lawyer walked into the room solo, and it's just like, now, in many cases, of course, they weren't local counsel. They were like from California or Wyoming. Pick your place.
Not part of the suspension debarment committee.
Right. So they walk in solo, and it's just like, well, this is a non-starter. Right. So these engagements must be shepherded and managed by counsel, and ideally a competent, knowledgeable counsel. But they have to be ultimately led by the client, by the company, by the individual. SDOs do not want to hear from the lawyers, and they don't want to hear, they don't want a 40-page brief on why the law may or may not be applicable. They're far more interested in, okay, this type of conduct occurred, and the role of the SDO is to not, be the line ref, to say, oh, well, nope, you crossed the line, or, oh, nope, you didn't cross the line. When you're trying to parse a legal argument with an SDO, you failed.
Not a good spot.
Yeah, not a good spot.
Okay, well, that about wraps us up. We are going to be sending out an email tomorrow with the recording and the slides from today. There's a couple extra slides that we didn't walk through, but they outline the factors that Rod mentioned, the FAR factors at 94061, the U.S. sentencing guidelines, and the FCPA guidance, the 10 hallmarks of an effective compliance program. So those will be included in the slides. With that, I'm going to go ahead and wrap things up, but before I do, I just want to remind everyone that next month, November 28th, so after the Thanksgiving holiday, we plan to have our November webinar, and that'll be on the Procurement Integrity Act, one of the issues that actually violations of can lead to suspension debarment. So it's definitely a very good topic to talk about after today's discussion. I also want to let everyone know that CLE credits for today were available, and a code will be sent out in the comments box shortly, if not already. So you have that for your CLE credits. With that, I want to take time to thank Rod for spending his hour and a half with me. I do appreciate it, and thank you all for joining us as well, and hope to have you join us next month.